We are here for another episode of the Common Law History podcast. As ever, I've got no idea what case in the history of law, English common law, that we're about to discuss. Victoria Ramshaw is joining me, my colleague from the Anson's Law Lichfield office. Hit me with it, Victoria. What case are we discussing today?
So you might be aware of it. I do have a prop.
Do we love a prop?
I've got a prop with me. So I have a can, unfortunately a can rather than a bottle, of ginger beer.
For the first time, I know what case this is, just based on that. I mean, this is the case of Donoghue and Stevenson.
It is the case of Donoghue and Stevenson. So it's a key case. It introduced the duty of care where there wasn't already a contractual relationship.
So we're talking here about the law of negligence. In effect, the properly establishing the law of negligence in English law, right? Yeah,
so obviously it developed much more since then, but this is the key case that said you don't have to have a contract with someone. You have a duty to look after people that are not contractually bound to you. So prior to this, we've got cases where there was negligence claims, but it was negligence in relation to a contractual relationship. So, for example, delays in delivering goods. As part of the contract, there was that duty to...
Yeah, loads of cases there would have been in Victorian times, people getting injured on trains, right? And presumably, up until this point, if you got a train ticket, if you bought a train ticket, they've got a contractual obligation to look after you. But if you hadn't, for whatever reason, you couldn't bring a claim despite being injured, despite losing, having goods damaged or anything like that, until this case hits us. So what year are we talking about?
This is 1932, so just before the Second World War. Yeah. And this is actually in Scotland.
Okay, yeah.
So, but it was dealt with in the House of Lords,
which is the old name.
It's the old name for the Supreme Court,
right?
So the cases used to go, they'd be heard at the local courts, then Court of Appeal. You go up to House of Lords as the final, final destination of the
final
of
boss,
case.
of course.
The final boss.
I'd be for final boss, court, final boss. Now. The facts of this case are a bit like a bit ick, right?
Yeah.
So go on, hit me with them.
So Mrs. Stevenson went to a cafe with her friend.
Right.
Her friend went up to the counter and purchased 2 bottles of ginger beer.
Do you know, I'm actually going to have a swig of the ginger beer. So keep talking, right? She goes up.
Watch it as it's pouring.
Yeah.
So she drank the first half of the ginger beer. She poured it into a glass. She enjoyed her ginger beer. When she finished that glass, she then poured out the second half. And as she poured out the second half, I noticed that you've only poured out half of that can of ginger beer, be careful.
I'm trying to make this dramatic as we can.
As she poured out the second half of the ginger beer,
I'm doing that now.
A snail fell out into her glass that had obviously been in there a while. It was decomposing. And obviously... it was disgusting, but it also made her really, really ill. So she had gastroenteritis because of it. So
it wasn't just she puked up. She got
extremely ill. So the problem was, who can she actually go to bring a claim for that? She didn't purchase the ginger beer, but she was the one that was injured by it.
Yeah.
So there was no contractual relationship between her and the cafe.
And the person who bought it can't sue because they've not suffered any...
They've not suffered an injury.
No.
So what Mrs. Stevenson did... what Mrs. Donoghue did was...
Did we get that the wrong way around to start with? Donoghue's the claimant, right?
Donoghue's the claimant.
Yeah. So it doesn't matter if we got it the wrong way around because everyone will know what we're talking about.
Everyone knows. So Mrs. Donoghue brought a claim against the manufacturer of the ginger beer.
I mean, it's their fault, right?
So
probably.
They'd manufactured these ginger beer. They'd put it in bottles that you couldn't see through. They were just the standard opaque brown bottles. So there was no way for the cafe owner to have seen that there was something in there. There was no way for her to have seen or a friend to have seen. So it was down to the manufacturer that had let this snail into the ginger beer and had contaminated it. So she brought a claim for £500. So obviously not a large claim nowadays, but in 1935...
Yeah, I bet you it's probably almost like 10 grand now.
The courts had to then consider how do they establish a duty there because she's got no contractual relationship with the cafe owner. She's got no contractual relationship with the manufacturer. So we had to then review the case, and it was Lord Atkin that decided that you have a duty to look after your neighbours. So it's the neighbour principle.
Okay.
So he said there was a reference to love thy neighbour. It also extends to protect your neighbour and don't let your neighbour be damaged or injured by your actions.
And I seem to recall there were hints and sort of whilst it had never been established, there were areas in cases in the past, Victorian cases, where the sort of forerunners of this case had started to be established. So
there are a couple of cases that didn't go all the way to trial that were trying to establish this principle. And also prior to this, they had established that if the goods were inherently dangerous, then the manufacturers did have certain duties to make sure that they're not harmful and they don't harm people that use them. But this was the first one where, well, ginger beer is not inherently dangerous.
No.
So they had to establish a broader duty there.
And, I mean, my one comment in the first instance, this factory, I mean, you could sort of see if, I don't know, something jumped into a bottle as it's been bottled like a fly or something, but the nature of a snail, right? I mean, blooming hell, they're relatively slow-moving creatures, right? This has happened in slow motion. But regardless of that, it's quite a seismic case because it is vastly expanding who any individual owes responsibilities or company owes responsibilities to, right? Which is, in effect, everybody whom it is reasonable for you to owe a duty of care to.
Mr. Stevenson was actually required to make sure that he bottled the beer and manufactured the beer in a way that was
taking it outside, almost to demonstrate the point. What would be unreasonable would be if somebody was injured in the act of smashing it against their head or something like that, right? That would be sort of a misuse. You're not in, as the manufacturer, meant to anticipate flagrant misuse like that, right? Yeah.
No. So it's an objective test again. So it's so this is just reasonable. So what a reasonable person would understand as someone that could be affected. So not someone being thrown a can of ginger beer necessarily, because how could you foresee your can of ginger beer being thrown at someone's head?
Yeah. But a criminal actor as well, yeah.
Yeah. Whereas actually drinking it, well, that's
in a cafe, right? That's the point.
Purpose of having the ginger beer. So that is clearly going to be foreseeable there.
Yeah, and that makes sense. And then, this, what flows from here over the next almost 100 years is vast expansion of the law of negligence.
Massively.
And imposing quite sort of almost an insurance industry gets built upon this to protect manufacturers and employers and schools and everyone really, that if they do an act which just cause somebody to suffer an injury or a loss, that they can be made liable for what they've done.
So the courts have then had to try and limit that. So at first it was quite broad. It's you've got to be careful not to commit any acts or omissions that could harm your neighbour, but then you've got to limit that to, well, what is foreseeable? So like the Caparo case, that was where a steel manufacturer had their electricity supply cut because someone negligently cut through their cables.
Yeah.
And the courts then had to decide, well, what's foreseeable? The claimant in that case tried to claim that shutting down the factory for the full time was foreseeable loss. But actually, the courts then had to limit that. Well, what was actually foreseeable? You had steel actually in being melted down. Well, that's foreseeable. You've lost that.
Yeah.
You've lost the profits from that bit of steel, but then you've got, well, how long did it take for you to to fix your electricity supply? Is it foreseeable that you could have been shut for a month, or is it more reasonable that they could foresee you being shut for a few hours or a day? So the courts then have to assess that, and that then becomes very case specific.
Yeah, no, and the facts of any case. I mean, broadly speaking, the law of negligence is, first of all, in effect, the first thing that you need to establish is what is established by this case is there a duty of care? Yeah. And a lot of the time there is, but there won't always be a duty of care. The further somebody away from the anticipated use of a product is, the less likely it is that you own the duty of care. There then has to be a breach of that duty of care. In this case, clearly there was a breach of a duty of care insofar as somehow they'd allowed the snail to find its way into the bottle. And then the next part, or the next test, is that the breach has caused that individual to suffer injury or to suffer a loss. I guess in circumstances where Mrs. Donoghue had Crohn's disease or something, or it could be argued, or there was another cause for her gastroenteritis. And apologies, I'm no doctor, so if I just mixed up two things that are completely unconnected, I'm sure I have. That's often a defence that people will use, or something that you've got to establish anyway, that the breach has caused the person to suffer.
Then the other
loss.
thing they look at is whether there's any contributory fault by the person. So, for example, if Mrs. Donoghue in that case had seen the snail in the beer and then carried on drinking it.
Yeah, or was drinking it alongside, I've seen somebody on one occasion who was quite impressed do the hot buffalo wings challenge. If she was doing that alongside it, then, and this person who did it, no problems, just swallowed them all down with the hottest sauce going on them. But if she was doing that might have contributed to the gastroenteritis, you would think. Yeah,
so other things that they specifically do, it will also be taken into account as well. Yeah, and it's also been broadened, so it's then, well, who's liable as well? So we see in employment law, well, acts committed by employees in certain circumstances, it's now broad enough that the employer could be liable in certain circumstances. So it's broadening it out throughout the years, nearly 100 years
of growth. And as you say, the case law has gone in all sorts of different directions. But I think some of those areas are a topic for a different podcast. Perhaps we'll get another negligence common law case in the future. But thank you for coming on to discuss this case today, Victoria.
Thank you.